and the arguments raised. So use your time accordingly. While you've all been allocated 20 minutes, you don't need to use it. If you don't have anything left to say and we don't have any more questions, everybody would appreciate it if you would just stop. Finally, you should be aware that we are audio and possibly video recording these proceedings. So when you approach the podium, please clearly state your name and who you're representing. If it is being video recorded, within a short period of time, you'll be able to see the video on YouTube. With that, counsel for the appellant.
Good morning, Your Honors. Roger Cohen on behalf of petitioner Wells Fargo, and my partner Kathy Sandweiss is also present. Your Honors, the basic issue presented by this petition is whether the supersedious bond requirements of ARS 122108 and the implementing rule of the Civil Appellate Procedure, Rule 7A1, constitute the exclusive means of obtaining a stay pending appeal. There are two sub-issues to that. One is whether 122108 and Rule 7A1 are applicable to non-monetary judgments, injunctions, declaratory judgments, other types of final judgment that do not involve damages as discussed in the statute. The second issue is, do the courts retain authority to condition stays on by imposing security devices other than a supersedious bond? Now, the court directed us to the second issue, so I'll talk about that first.
Counsel, let me make sure I understand something in the record. So there's an underlying money judgment in
Yes,
another
sir.
case that Wells Fargo has against Mr. Hogue. Is that
$3.2 million, $3.4 million, something like that, Your Honor.
And there's no stay in that case.
That is correct.
There's no bond, no stay. So Wells Fargo is free to try to execute against any assets it can find under that case. And the problem is, just to sort of summarize it to make sure we're on the same page, is that Wells Fargo has found an asset. But there are trusts in the Bahamas.
The trustee resides in the Bahamas, Your Honor.
And there's a spendthrift clause, which has been stricken by the trial judge in this case, as well as Mr. Hogue has been ordered not to interfere with any efforts to collect, and that's what's been stayed without any kind of security.
That is correct, Your Honor.
Okay.
So
go to the bond issue. That's where you were, I think. You were going to the bond
yes,
issue.
Your Honor. What I want to do is talk about the second point, which is the one that the court directed us to. And the background there is the enactment of 122108. So in 2011, the legislature determined that there was a problem of excessively high judgments and decided that the remedy for that would be to restrict the amounts of supersedious bonds. In the cases of overly large judgments was the word in the enacting statute. And the effect of 122108 in general, there are some exceptions, is that the amount of a supersedious bond is the lesser of the damages, or 50% of net worth. But the statute doesn't say anything about alternate means, alternate bases for staying judgments. It just says that if you're entitled to a supersedious bond, this is what happens.
Actually, it doesn't have that language in it either. It says the amount of the bond
Correct, Your Honor.
that's necessary to stay execution. I know, forgive me, because I know where you're going, I think, because we struggle with this issue. Let me ask you this. A lot of times, instead of a true bond that is backed by a surety, a party will post a supersedious bond in the form of a CD, or, for example, a cash bond. We call it a cash bond, but it's really not a classic bond because there isn't any surety. Why wouldn't those arrangements apply here? Why wouldn't the statute apply to that? It's a bond. It's
Well-
just in a different slight format.
If the court is suggesting that that would be a way around the statute, I'm fine with that.
No,
I think the
suggesting
intention
that-
of this, I think the
No, no,
intention of
Mr.
the
Cohen,
statute,
please.
Your Honor.
Please,
I'm sorry.
If I may, please, I'm sorry. I'm suggesting and I'm questioning because this is a hard issue and I've struggled with this, is that it says the amount of the bond. Is bond a term of art? Is it a concept that requires a surety? For example, when I was in private practice, I many times posted a supersedious bond approved by the court, but it took the form of either cash or a CD. Now, does the statute apply in that situation or not?
I think it does, Your Honor, because I think the intention is not the form of the bond itself, but the amount of money that the defendant has to come out of pocket to prevent the judgment from being enforced. And as Your Honor is aware from dealing with supersedious bonds, when no surety will issue a supersedious bond without having collateral in the full amount of the judgment. And whether that collateral goes to the surety or whether that collateral goes into a CD that is pledged or whether that's simply cash deposited with the clerk of the court, that is a bond in the sense that it is a financial undertaking by the defendant in an amount equal to the judgment. But the question, though, remains, did the legislature intend that to be exclusive, and did the Supreme Court, in enacting Rule 7A, intend for bonds to be exclusive as to the available remedy to stay enforcement? And the best answer to that, we believe, is found in the order that was entered by the Supreme Court amending Rule 7A, or actually all of Rule 7, effective January 1, 2012. And that's important because the changes in the rule at that time are easy to track. I mean, since when the entire rules of civil appellate procedure were revised in 2014, it looks different, but the substance remained the same. But when you look at the order from the Supreme Court, it's very clear. So
This is the order that Justice Birch signed effective 12/13/2011 that changed Rule 7
Yes, Your Honor.
to contain the tracking language effective January 1, 2012.
Exactly, Your Honor.
Okay.
And so in the first sentence of Rule 7A1, it says that, except in cases involving custody of children, whenever an appellant entitled thereto desires a stay on appeal, he may obtain a stay by filing a supersedious bond in the Superior Court in accordance with, and this is the underlined, any applicable statute and these rules. So that's the any applicable statute is the reference to 122108. Then 3 sentences down, it says, the court may make any further order other than or in addition to the bond appropriate to preserve the status quo or the effectiveness of the judgment. So this is our Supreme Court's order implementing 122108. And the effect of that in terms of the intention could not be clearer. The Supreme Court did not believe that it was limited to bonds. The Supreme Court believed that notwithstanding the reference to 122108, that the court retained the discretion to make further orders other than or in addition to a bond to preserve the status quo. And quite frankly, Your Honor, we think that that's the end of the inquiry.
Well, okay, let me ask you this then. The Supreme Court, I noted that, retained that language, and there's somewhat quite similar language in Rule 7C, as you've argued. When then a court, whether it's a trial court or an appellate court, exercises its explicit authority under the rule to maintain to preserve the status quo, or to preserve the effectiveness of the decision. Help me understand how I distinguish what that court is doing versus a bond, in which it is staying the judgment. They seem awfully similar to me.
Well, in this case, it's actually fairly easy to identify the difference. Okay. Mr. Hogue is receiving these payments of $30,000 a month. Mm-hmm. And Wells Fargo believes it's entitled to those payments. The trial court determined that Wells Fargo is entitled to those payments. Mr. Hogue doesn't want to turn them over. He wants to receive the payments and spend them. And once they're spent, they're gone, and the underlying trust is a diminishing asset because every year 10% comes out, and so if you let it go on long enough, it's gone. So the alternative proposal, or the alternative remedy that we proposed as a means of preserving the status quo, is simply that those payments be impounded, deposited with the court, put into escrow. Something can be done with those payments so they don't go to Wells Fargo, but they don't go into Mr. Hogue's pocket. That is an example of a remedy that is security. It's something that would preserve the status quo, but it is not a bond. I mean, in other circumstances...
Isn't it, here's my, I know it is not technically a bond. It's a duck is a duck is a duck. It's not a duck, okay? I know it's not a bond. It has, however, the practical effect of a bond. A bond, a supersedious bond, protects both the appellant and the appellee. Either way, there's protections for both. It stays or maintains the status quo. There can be no execution by the appellee. It maintains the status quo. It preserves an asset. That's what supersedious bonds tend to do. This other arrangement, isn't it doing effectively the same thing?
No, Your Honor, and here's why. Because in the supersedious bond, the defendant has to reach into his pocket and come up with money to bond over the judgment. What we're talking about here is the defendant doesn't have to come out of pocket at all. He simply has to place the disputed race, the thing that we're arguing over, into a place where it can be held and preserved so that the ultimate judgment is not frustrated. I mean, if we're not entitled to do that, then the whole exercise of having received a judgment is made a mockery. Because how do we enforce this judgment while he goes and spends the money in the meantime? And, Your Honor, what then do we make of that language in Rule 7? Because the similar language exists in the current rule. It says the Superior Court may enter any further order in lieu of or in addition to the bond, which may be appropriate to preserve the status quo or the effectiveness of the judgment. And for that matter, what do we make of Rule 62C that talks about providing security where a party seeks a stay of an injunction pending appeal? And so maybe the difference is that there's a difference between a supersedious bond and an injunction bond. Because Rule 62C still exists. And 62C says, the court in its discretion may suspend, modify, restore, or grant an injunction during the pendency of the appeal upon such terms as to bond or otherwise as it considers proper. So again, our Supreme Court believes there's a difference because it knew about Rule 62C and it knew about that extra language in Rule 7A1 at the time that the rule was amended to conform to 122108. So unless we're going to say that those provisions are completely nullified, 62C is out the window, the provisions of Rule 7A1 that give the court discretion to provide other forms of security are out the window, then we have to give some effect to that. There has to be something else. And the difference, again, seems to me that a supersedious bond is a general bond that precludes enforcement of the judgment generally. If Mr. Hogue wanted to come up with a $3.5 million bond or whatever the amount would be, then we couldn't enforce the judgment at all. But that's not what we have. What we have here is a specific order that gives Wells Fargo the right to a specific stream of payments.
Actually, I don't
includes
see-
injunctive
I think-
language.
If you make that argument that they have a right to a stream of payments, you fall squarely within the statute. I don't think you want to make that argument, based on your briefing. The judgment at issue in this case doesn't order any payment by Mr. Hoag. It declares the spendthrift provisions invalid, and it orders him not to interfere with your efforts to, or your client's efforts to collect. So there's no payment stream here.
Well, it's a payment stream to him, Your Honor, but
Yes.
if I misspoke, I apologize. But my point is that Wells Fargo has the right to attach or garnish, whatever procedural mechanism might be used, those payments coming to Mr. Hoag. That's what the court said, that the spendthrift provision is unenforceable, and enjoined Mr. Hoag from preventing us from obtaining access to the payments from the Crutz. And Mr. Hoag, we could do that by garnishment, except that, he conveniently sent the trust off to the Bahamas. But we could also do it by getting a turnover order against the defendant, who's the recipient. And what the effect of the stay that is now in effect is that we are prevented from getting a turnover order. And that is different from a supersedious bond that prevents us from doing any collection efforts. Because the Judge Kessler acknowledged we do have the right to be enforcing the judgment. But the bond that we're talking about is simply a bond or other mechanism, and that's why we provided the alternative mechanism of an escrow arrangement or some kind of a sequestration that would allow Wells Fargo either the ability to enforce the judgment or to have some protection during the pendency of the appeal, lest Judge Rogers' orders, the ultimate orders of the court, are negated because the money, the asset that we're fighting over will be gone by the time we get to the end of the appellate process.
But what you're really saying is, whether it be called a bond or cash bond or CD or something, deposit with the court or escrow account, is that Mr. Hoag has to come up with some asset that he cannot touch, that is in the hands of a third party, whether it be the court or an escrow agent, to preserve the status quo. And
I suppose that's true, Your Honor, but again, Rule 62C says that the court has that discretion.
I understand that, but it does sound to me, it may be a duck is a duck is a duck is a duck, but it's just not called a duck. It's not called a bond. It's called some other security arrangement. And it serves the same purpose.
Or it's a bond, but it's not a supersedious bond. The supersedious bond, again, is sui generis. It is something that stops all enforcement. That's not what we're asking for. We're just asking for
Nothing preventing you from enforcing it.
Correct.
There's no stay.
Well,
but
there is a stay that prevents us from enforcing this
Right.
judgment, and there's nothing in the statute of the rule that would prevent either the trial court or at this point this court could, under Rule 7C, impose conditions to the granting of a stay. So I have less than 2 minutes left, unless the court has anything else.
I am a little curious if, to preserve the status quo for Mr. Hoag, if the money all goes into an escrow account, are you proposing that something has to happen every time it goes into the escrow account? Does there have to be a determination, or is there a determination before deciding how much goes in? If that's the only money that he has to live on, then the status quo is not necessarily preserved for him. Is there some alternative proposal or?
Your Honor, it's interesting. I don't think so. For better or worse, this is not exempt money. It doesn't fall under any personal property exemption. Mr. Hogue has just decided, I need that money to live on, therefore I can't pay it to you, Wells Fargo. It doesn't work that way. It's not wages. You know, if it were wages, you only get 25% of the net take home. It does not fall within any other enumerated category of a personal property exemption under Arizona law. So, you know, one might have some sympathy, but that's the way it works.
And he presumably could propose some other type of arrangement, use that, some sort of bond to.
Well, certainly, but what we're saying is that if the sticking point is bond, then the way around that is that he gets these payments and they can be sequestered for the time being. And if he wins his appeal, they'll go to him. If he loses the appeal, it goes to Wells Fargo. That's, in the debtor-creditor world, for better or worse, that's the way it works. And he has no right to use that money to the detriment of his creditor. Any other questions, Your Honors?
Thank you.
Thank you.
I know you've got 2 seconds left. I assume
I'll
you'll
use
keep
them
us for a
wisely, Your
bottle.
Honor.
Good morning, Your Honors. Chad Hester on behalf of the real parties in interest, Robert G. Hogue and the Robert G. Hogue Living Trust. A couple things I want to begin by clarifying is Your Honor mentioned that your understanding was that an asset of Mr. Hogue's has been found that they're trying to collect. I need to clarify that that is incorrect. The CRUTs are not an asset belonging to Mr. Hogue. Mr. Hogue created these CRUTs, and that's the subject of this appeal, and I don't really want to argue too much of our appeal, but just to be clear, the CRUTs are not Mr. Hogue's assets. So when we're talking about collection efforts and things, we're talking about collection of assets. I just want to clarify that for the court.
He funded the CRUTs.
Years ago under the IRS rules and regs that allowed it to do. So, but it's not something that he can just as easily go and, hey, I need that asset back. It's no longer
He
his
is the
property.
beneficiary.
He's an income beneficial. He receives an income beneficial interest, but he doesn't even receive a distribution of the assets. Secondly, when they talk about dissipating assets, that is something, number one, he doesn't control whether the assets are dissipating or not. He receives a beneficial income interest based on the income of the CRUTs that year. So, for example, they make whatever the value is at the end of the year, he's paid a percentage on an interest.
Why isn't that dissipating the asset, though? If it's not paid to him, it would presume if it.
He
were to
doesn't
stay in
control
the-
that. The concern is he does not
dissipating.
control what he
Still-
receives.
Even if it's still dissipating.
Right.
He doesn't control the amount.
He doesn't control the
language
amount.
of The trust requires the trustee to distribute.
Correct.
It
And
speaks in terms of shall.
correct. And the judgment that we're talking about here, this declaratory judgment, talks about him, the wanting to receive this beneficial interest and have it diverted. The problem is the language talks about that he won't interfere or do anything to prevent them from garnishment, attachment, just,
That deals with your appeal.
yeah,
That's really your appeal.
correct. I just wanted to clarify that issue for you.
I did have one question about the
Sure.
trusts. As I read them, the trustee shall distribute a percentage of the net income valued as, I think, it's January 1 or
Correct.
something like that. And then if, upon his death, it goes to a Mrs. Hogue, is that a current Mrs. Hogue or is that a former Mrs. Hogue?
That is a former Mrs. Hogue. There is no current Mrs. Hogue.
There is no current Mrs. Hogue. Oh, okay,
no
so
current.
this is the former Mrs. Hogue.
Correct.
Okay.
With respect to, talking through the statute and trying to understand some of the clarification, I believe when you look at the rules that Judge Rogers looked at in the process he followed, I believe he was correct, obviously. But the reason is you look first to this statute, and when you're a trial court judge, you're going to look to the rules, and number one, what am I required to do first? And I think the language is clear. You look at what is the judgment that's being appealed, and I think the Jansen case discussed what a judgment was and what it is or isn't. If there's a point where they determine there's a number that should be applied, then I think we would look to things such as Rule 7C or conversely Rule 62C, where it has a may. The may language shows up in this, where the court may at that point determine, do we need to do something to secure or do not. But I believe Judge Rogers was correct when he said the analysis stops if it's in this case, which we all agree, it's a non-monetary judgment for declaratory judgment. There is no monetary amount attached.
But
With
the
respect,
statute refers,
excuse
the
me,
statute refers to, let me just grab it.
which the
Statute, no, go here.
122108.
I mean, it refers to obtain a judgment under any legal theory, the amount of the bond, okay? And then it talks about the total amount of damages. And then later on talks about, talks about damages. But here, how can a court say, well, okay, I'm going to determine this if there are no damages?
Well, and that was our position, Your Honor. There was no damages in this case. We don't dispute that there's a
But the
judgment.
statute only refers to damages. The full amount, post a bond up to the full amount of the judgment, the total amount of damages. It repeatedly refers to.
Right.
So
Amounts.
amounts. So wouldn't that indicate that the legislature was saying, yes, if you've got a money judgment, then you have to post a bond. But if it's but here there is no bond. It's no. I mean,
I would argue that damages would equate to a remedy as well. When the court's looking at what is the remedy that was received in this judgment, the remedy here, there's still a non-monetary judgment in place. And I may not understand your question correctly, Your Honor, but there is nothing by which the trial court could determine what damages there are. If we're talking about the injunction process here,
well, that's why the other rules come into play.
they do. But again, you got to have something to determine what is the value. I know there's some argument in the Wells Fargo supplemental briefing that talks about the example of a Ferrari. Okay. Now,
It's hard for me to relate. I was thinking more Toyota.
I was thinking even lower down the. But let's all go to a Ferrari for a minute, okay? The Ferrari, number one, it's an identified tangible asset belonging to the judgment creditor that he has control over. There's an immediate and irreparable harm that could happen. Apparently, that someone goes out and joyrides a Ferrari and crashes it and does. So there's some protection that needs to be placed. Point being, though, an asset has been identified, the value of it has been ascertained that is subject to the injunction. Other cases where we talk about injunctions being placed to prevent somebody from dissipating an asset, there's this fixed value attached, there's something attached, or there's identifiable shares owned in a company, or if, for
Why isn't
example,
there an identifiable amount to the extent the assets of the trust are distributed to Mr. Hogue? Isn't that an identifiable amount? There are assets in the trust, and
but that hasn't been determined by the trial court. We're looking at right now what was in front of the trial court.
the trial court has determined that Wells Fargo that is entitled to get around the spendthrift provisions.
Correct.
So there are assets in the trust, and to the extent they're distributed, we know there's an amount in there. Isn't that the net effect of the order? And I guess my question is, why doesn't it come within 7C to make any other order to preserve the effectiveness of the
I think
judgment?
because the order that we're appealing from is directed against Mr. Hogue, not the Crutz. And that's why I want to be clear of it. The Crutz control the assets that are being dissipated, not Mr. Hogue. I look at it similar to an employer-employee relationship. If I had a judgment against Your Honor and you decided you didn't want to pay, I would garnish your wages, or I would try and get in front of you to attach your wages or do something to stop that money before it gets to you. Because otherwise I come to you and I say, hey, when you get your paycheck, please turn it all over to me. And so here, though, this order and this declaratory judgment that we're talking about, it enjoins Mr. Hogue from not doing something. We recognize that language. But Mr. Hogue doesn't control whether, when, or how any of this distribution will take place. And that's why there are other avenues available under the 2012
Doesn't have an
case.
ability to decline a payment from the trust?
He could. I guess he could say, don't pay me, but again, we can't be in a situation where he can't direct as a beneficiary pursuant to any court order as far as I'm aware. Pay here, pay there, do this, do that. He can decline it, and he could probably say, yeah, go ahead and pay my bills, but whether he chooses to do or not, again, we're talking about an injunction preventing a dissipation of CRUT assets, which Mr. Hogue does not control. Not a question of whether or not he's willing to.
You're saying they're no longer trust assets once they've been distributed to him?
The beneficial interest, once it comes to him, it is now You know, if he gets a $10,000 payment into his bank account, for example, that's now his money. You know, he'll spend it.
Not an amount that the court could then order some kind of relief on under the statute?
They could order if they had that hearing take place. And that was part of the argument where we said there was never an injunction hearing that took place to even
I
determine
understand
that
that,
amount.
But on
That's
that
like-
point,
Right.
you didn't, forgive me, but
Yeah, I'm
Mr. Hogue did not make any of those arguments. The reply brief on this point is really quite clear. You're right, this was not an injunction under Rule 65. But there was no request that there be any of the hearings under Rule 65. Your client agreed to the language that's at issue here. I know there was an objection on other aspects of this, but, so, let's not talk about Rule 65, because I don't think that's not your strongest.
But so let's assume that he's getting, let's just assume you have a trust like this, and Mr. Hogue is getting $14,000 a month. And the judge basically says, spendthrift trust is no good. Mr. Hogue, don't interfere with Wells Fargo's attempts to collect. And why couldn't Wells Fargo say, okay, fine, we're going to get an order against Mr. Hogue to turn over, every time he gets the money, immediately turn that over to us. And if he wants to stop that, he can put that money into an escrow, and that money would fall within the terms of the statute as a, quote, bond, end quote, because it would be placed in an escrow or deposited with the court, and there's an amount. It would be the total, the court talks about the total amount of damages, but it's the total amount of, the effect of the order is, it would be the total amount that he gets that would have to be sequestered.
Okay.
Why couldn't that be done?
Because I think, you know, we talked about earlier is that when we talk about, that is not something that's being used, for example, an asset to set aside what we talk about. When we talk about bonds or alternate security remedies, I believe in situations of a security, it's when, you know, the other part too is who is the moving party that comes back to say, I can't do a bond, I can't do these things. It would be Mr. Hogue coming back to the court.
But Mr. Hogue could say,
I can't.
I mean, under the statute, there is an amount.
Right.
The amount is, let's say, in my example, it's $14,000 a month. And so the court could say, fine, if you don't want them to collect that, place that amount into escrow. Because that's the amount, the effective amount of the damages that in essence, I'm awarding.
Well, I think, you know, Your Honor, in this situation where we have a separate case, in 2012 case where there's an actual monetary damage amount, by Mr. Hogue doing that, would he in effect be staying collection of the two? Because we're relating this back to an amount they're trying to collect against the 2012 judgment. Are we now combining?
There is no stay, but there is no stay.
And there is no stay in the 2012
in essence,
judgment.
all this is an effort to collect
In the 2012
in
judgment.
the 2012 judgment, where there is no stay.
Right.
And he's getting a stream of income, and the court could say, fine, if you don't want to pay that stream of income over to Wells Fargo, place that money into an escrow.
Right.
And that's the amount of damages, because it's a subset of the damages in the 2012 judgment. It's a subset. There's 3.2 million. Here's an income stream. We've identified, okay, you have to pay that over as part of the collection effort. If you want to stay, you know, because I've stricken the judge has stricken the spendthrift clause, ordered him not to interfere. Wells Fargo wants a turnover order to get that. He says, I don't want to turn it over to you because I may never get it back if I win my appeal.
Correct.
And the answer is, well, okay, then place that amount as a, quote, damages into an escrow account. Why couldn't that be done?
Why couldn't it be done? I think.
And why doesn't that fall right within the statute? Assuming this was, because your argument essentially is this applies, the statute applies here and there's zero damages.
Correct.
But in essence, the court is saying, no, there's the equivalent of damages, which is this income stream that he's getting.
I don't believe the court has said that, Your Honor.
No, but isn't it? I mean, it has, but
I mean, respectfully, I disagree. I don't believe that's ever been a
I know it hasn't
finding.
explicitly said that, but it has said Wells Fargo's entitled to this money.
No, Wells Fargo's entitled to
The money that,
not from Mr. Hogue. I mean, let's be clear. And again, this is part of the other appeal. Let's be clear. The court has not said Wells Fargo. They've said that the spendthrift provision cannot prevent Wells Fargo from collecting any income beneficial interest. That's as far as it goes, and that's what we're on appeal for.
Right, but the income beneficial interest is $14,000 a month.
But that has never been determined.
Well, but it could, in an evidentiary hearing, it could be determined how much that is. My hypothetical would
Correct.
be, okay, it's proven it's $14,000 a month. Why isn't that the equivalent of a damage?
And if that were the case, but you could consider that, but that's not a damage that Wells Fargo is suffering in this 2012 case. Okay, when the 2012 case is done, again, all the claims here, we're talking about fraudulent transfers, it all relates back to a core number of the 2012 case. Their damages will never be higher than whatever their principal and interest is in the 2012 case.
So this is a subset. This
Correct.
is sort of a subset of that amount.
I think really what this is, it's a fight over legal issues is what we're talking about. The damages aren't going to increase. There's no separate damage that's going to be awarded in this 2014 case. And because of that, I don't think you're allowed to then combine a 2012 judgment amount and start using calculations that are in that court, a completely separate case, to then establish how much is or should be damages, amounts we're receiving, how much are we being impacted by this act?
So why wouldn't that simply be the response to, if say they only had a $500 or a $50,000 judgment in the other case, and he's getting a greater stream of payments, certainly he could come in and explain why the amount that needs to be protected to preserve the status quo is not the entire amount that gets distributed to him from the trust in order to preserve the effectiveness of this judgment, because Wells Fargo isn't entitled to that amount. But it seems to me that would just be your explanation for you should only allow them to go after a lesser amount. But to preserve the effectiveness of this judgment, I'm having a hard time understanding why they shouldn't be allowed to either put that money in escrow or have him post a bond for the amount of whatever you want to call it, but some sort of security, at least for the present value of the stream of payments that he'll receive during the pendency of the appeal.
I understand. I understand the questions and concerns here. Is we all look at this when we back up and go. Basically, everybody's question is, why doesn't Mr. Hogue just pay what's owed under this 2012 case? Why couldn't he have a hearing? We probably could have a situation where the court, had they chosen in their analysis to have a hearing on a bond amount to determine, and again, when you look down the statute beyond these three factors, there's an upward adjustment. Is Mr. Hogue intentionally dissipating assets? Okay? There has been no showing of an intentional dissipation of assets. So therefore, I think to go to your position is, why can't we talk about these things? We have to have a showing. Perhaps Wells Fargo could have moved to show some intentional dissipation of assets to the trial court. They chose not to.
But in essence, as I understand your answer to my question is, the reason that you don't treat the income stream as damages is because there were no damages in this case.
In this case, correct, Your Honor. And
That's your position.
our position is this case, this ruling that's on appeal, relates to nothing with respect to damages. And we know for a fact Wells Fargo is continuing to its collection efforts in the 2012 case and has even filed another separate action trying to collect.
What do you do with all the other rules, as your opposing counsels pointed out, Rule 62, Rule 7, even as it exists now, that gives the court discretion in non-monetary judgments to give other forms of to issue other types of stay relief?
I believe, Your Honor, and reading the rules and as I understand them, I think if the court first, through its analysis of the first three prongs there of the judgment amount or the judgment amount or 50%, if you get to that point, then you get to the second prong of this is whether or not my client, for example, Mr. Hogue, if we determined there's a damage, this is the amount, Mr. Hogue, I think it's his obligation to then come in under the Rule 62C and say, Your Honor, to the trial court, I can't post this, I won't live. That's when the court's discretion will then come on, where they can adjust or come up with the alternate forms of maintaining a status quo.
That's the point, the alternate means of maintaining a status quo. Because even the statute in Rule 7A talk about the means of surviving, undue economic harm. If the award But I mean, I'm trying to think of an example. If two people are partners in a business,
Correct.
and there's a dispute about the business, and ultimately one party gets a non-monetary judgment.
A declaratory judgment.
Let's say that means that the appellee gets total control of the business.
Mm-hmm.
And he wants some type of, the appellant wants some kind of relief, some kind of stay, because he's afraid that, gee, if I don't get some kind of stay, this guy will just drive the business under.
Mm-hmm.
And if I win on my appeal and I have an interest, what am I going to do? You're saying that there's no means for that person to get a stay?
No, I believe there is a means for that person to get a
Is that?
Well,
He can get a stay, but he doesn't have to put, and then, but on the other hand, it stops the appellee from running the business.
well, and that's where avenues such as a receivership are put in play. You know, you can have a receiver appointed. You could,
Could you have a receiver appointed here?
I don't know how we could when you have a CRUT. Again, I don't represent the CRUTs or the trustee. I don't know how you could even get to that point.
Well, you could have in my example, you could have a receivership.
In your
appointed.
example, where two business partners, let's say both live here in Phoenix, are arguing, I'm down to 26 seconds, I apologize. I believe you could turn around and say, you know, either get a receiver appointed, or perhaps you take the, you know, you can set a valuation of the businesses at a certain time. I mean, there's things that can be done,
Yes, but if you set a valuation of the business at a certain time,
and it grows, or
and it's dissipated, that doesn't protect the appellee if he wins on the appeal, because it's dissipated. Wouldn't you have to say, okay, fine, I'll stay enforcement of my order as to who controls the business, but you're going to have to put up money to avoid that, to protect the appellee?
correct. And I think in the hypothetical here, that's where I started with the slight difference here is, in that situation, one party is controlling the asset that's at issue. That's not the situation here. Mr. Hogue doesn't control that asset. And I think that is the reason why, as to Mr. Hogue, the $0 bond, the non-monetary damage makes sense, Your
But
Honor.
of course, we're talking about the income stream, not the assets held in the Bahamas.
Correct.
Okay.
Let me ask a question,
I'm
I'm
sorry.
sorry.
No, go.
As I have reviewed the record, both before us in the special action, and the pertinent portions of the record that are in the Spendthrift Trust appeal that's pending. What precipitated this whole debate over the stay was the request for a turnover order filed by Wells Fargo in this case, is that correct? Okay. In that motion, Wells Fargo requested an order basically saying all checks, cash proceeds that he received from the trust should be turned either directly to Wells Fargo or perhaps put into a segregated bank account, and then they could garnish that. It would be a local account. As I was ruminating on this, as you're making your comments, it struck me that I'm not sure it made sense to have any stay in this case. What's going to be the stay? What is the purpose of a stay here?
Candidly, Your Honor, the reason we requested this stay is to try and minimize the legal fees on ongoing battles till we get an answer to whether or not
Yes, but
this spendthrift provision is correct.
if Wells Fargo had, instead of seeking a turnover order in this case, had gone back into the 2012 case and sought a turnover order, there's an amount there, there's no question there is an
Correct.
amount. Under the statute, there, you would have gone through the formulaic calculation. And it's just kind of, I sit here thinking, I think this may be, the turnover order was in the wrong case, but,
Well, and that was one of our arguments on our response to that issue, was the fact that here, again, maybe the right idea, I hate to agree, but right idea, wrong case, wrong situation. Here, again, this is a case where we're really dealing with some legal issues, and like I said, candidly, our goal is to try and keep Mr. Hogue's costs down as well as their costs. Nobody's disputing the 2012 case, the judgment, their collection efforts to try and collect against assets that Mr. Hogue has or not. I mean, there may be some fights as we go, but, here, it's simply, our idea is come to the Court of Appeals, have an answer on whether or not this spendthrift provision is correct or not. We'll move forward.
so basically, as a consequence of the stay in this case, 2014 case, the invalidity or validity of the spendthrift clause, that determination has been stayed.
Correct.
And also, the court has stayed the injunction or the order enjoining him from interfering.
Correct.
Okay.
I've got, as we're talking about this, you said it was filed in the wrong case. Now, normally in a collection action, I may be wrong on this, because I didn't do collections when I was in proper practice. I particularly avoided those kind of things. If I get a money judgment against someone, and I seek collection, and there's usually a debtor's exam or garnishment, that's done in the same proceeding, right?
Correct.
So in this case, what would have happened if you have this judgment, this 2012 judgment, and as part of the 2012 judgment, they tried to collect against the asset and get a turnover order. And to do that, they moved to the trial court in the 2012 case to strike the spendthrift clause and issue an order stopping Mr. Hogue from interfering with their collection efforts. Would that have been, and then Mr. Hogue said, okay, now I want to appeal that, but it's part of the same case. Does that mean there's a money judgment involved?
Quite possibly at that point, because there is a money judgment. And again, there we're dealing with a situation where, assuming they've done the takeover, the motion, the judgment debtor's exam, all these things, which they in fact did, and they discover an asset, usually it's a tangible asset. Hey, I see you're wearing a expensive watch today. Judge, order them to turn that over to me.
That would all be part of it, and in that case, there would be, your argument would be, well, okay, there is a money judgment, so I could have to post a bond.
Correct.
Mr. Hogue could have to post a bond for the, and so if they had consolidated the two appeals, the two cases.
The two cases.
Same thing would exist, right?
I believe if you can, consolidating the 2012 and the 2014 case,
Right.
But here, as it currently stands, there is no monetary judgment.
All right.
All right. Thank you, Your Honor. Any other questions?
Thank you. Thank you. Use it wisely, Mr. Cohen.
Very quickly, Your Honor. First of all, the assets.
Should we get another minute?
Oh, at
Because
least
we
a
really
couple, I
did.
think, to be fair.
Give you 2 minutes.
Thank you.
If you'll put 2
All
minutes
right.
on the clock.
First of all,
Wait. Okay, that's good.
the asset that we're talking about here is not the CRUT itself or the corpus of the CRUT. The asset are these checks and payments that are coming to Mr. Hogue that he clearly does control, number one. Number two, I heard counsel say this: damages equate to remedy, or damages equate to the remedy. Exactly. The damages here equate to the remedy that is being denied to Wells Fargo, which is access to these payments, these distributions that are coming out every month. And I think Your Honor's got to that in talking to counsel about the monetary value of the order. Now, one of the things we get off into these hyper technicalities in this case. Well, if you had done it in this case number, it would have been okay, but you did it in that case number, and consistently what is happening, and I mean, I don't know what else to say. That we are getting the defendant is using the technicalities of the rules as a sword to try to prevent Wells Fargo
Mr.
from
Cohen,
getting
that
what
was
it's
my
entitled to
point.
as a matter of substance.
That was my point.
Thank you, Your Honor.
That if they had been done in one case, all as part of one case, there would have been a monetary judgment, and a bond could have been posted. The fact that it gets filed in a different case, for whatever reason, it can't get posted, seems to me a little bit hyper-technical.
I
But that
agree,
was
Your
my-
Honor.
That was where I was going.
I agree, Your Honor. And by the way, the law permits a party, a judgment creditor, to sue on the judgment. There's nothing unprecedented or improper.
May I ask one other question? You started your remarks by explaining that the overarching issue is whether the statute and the tracking language in Rule 7 exclude, or rather the exclusive means to obtain a stay pending appeal. And then you identified the two sub-issues. If you are sitting on this side of the bench and you're writing this decision, outline for me the very strongest way to write this decision from your standpoint.
The strongest,
Strongest way, that what do you think is the most legally supportable way to write the decision you would have us issue in this matter?
well, the easiest way, I think, to get there
Well, there's
is to,
easy and there's hard. What is the best way, the most legally supportable, persuasive way to resolve the issues in dispute here?
that the statute is silent as to the procedure and requirements to be satisfied to stay a judgment that does not involve the payment of money, and that it is also silent as to the, it is not exclusive of other methods for
Other
effectuating a
arrangements,
stay, and to look at the totality of the statute and the rules after the enactment of 122108 and the promulgation of revised rules, Rule 7, and to acknowledge that unless the court is defined an implied abrogation of all these other rules that clearly give the court under Rule 62 the ability to impose conditions where there's a stay of an injunction, and to impose other conditions necessary to preserve the status quo, that there has to be some substance to those rules. And basically what it comes down to is either the Supreme Court is right or Judge Rogers is right, and we're betting on the Supreme Court.
So your argument is that the way you would word it would be you have to harmonize the rules in the statute.
I think that's right, Your Honor.
Any other questions?
No, that doesn't. Thank you very much, and thank you.
Thank you both counsel for your arguments. We will take this matter under advisement. We stand adjourned. Oh, I'm sorry, we will issue a written decision in due course. We stand adjourned.